Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 39th lecture series. This is possible because of your immense support and Almighty's will. Before we start our lecture, it is our everyday practice that we recite the preamble of the Constitution of India by having faith in the preamble that it is our reflection of the unity and divinity, and it is our commitment and sentiment also. So therefore I request each one of you to recite preamble of the Constitution of India along with me. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, we have gathered here to discuss about a very important topic, that is, what is the procedure governing special leave petitions in criminal matters. If we examine all the 5 years questions from 2019 till 2024 from the drafting paper, the most number of questions have come from draft SLP, either civil cases or criminal cases. So therefore we need to concentrate more on this topic, because there is no question which they have not dealt with specially petition. So such a vital topic, we need to concentrate more on Article 136. Order 21 of Supreme Court rules deals with special leave petition in civil matters, and 22 deals with criminal matters. So how am I going to approach this topic? That is very, very important. Though we have conducted series of lectures on special leave petitions, but it is our endeavor to understand what does Article 136 deals with. Article 136 of the Constitution of India, that deals with Supreme Court having the extraordinary appellate jurisdiction to grant special leave petition. How does it start with? Notwithstanding anything contained in this chapter, that is chapter 4, notwithstanding anything contained in this chapter, the Supreme Court may in its discretion grant leave to appeal against any judgment, any degree, any order, sentence passed by any court or tribunal, in the territory of India. This is extraordinary appellate jurisdiction, dear friends. So what is the difference between the appellate jurisdiction and extraordinary appellate jurisdiction? How Article 136 stands different from the remaining civil appeals? In my humble opinion, in civil appeal, where it says final judgment, final degree or final order passed by the High Court, whereas in Article 136, it says order means it includes interim order also. You will not find in the civil appeal. So that is a major difference. even against the interim order passed by the High Court or the other courts below, you can prefer SLP. You can file SLP, you can knock the doors of the highest court of the land against even the interlocutory order, though main matter is pending before the courts below. So that is widening the power of the Supreme Court, and passed by any court or tribunal, meaning thereby they have not approached against the order of the High Court. Generally, we prefer SLP against the order of the High Court. But in this extraordinary appellate jurisdiction, they give opportunity against any court or any tribunal. So it may be from district court also, you can directly come to the Supreme Court, provided you satisfy the Honorable Supreme Court that why you have come directly without approaching the High Court. This is Article 136 Clause 1, dear friends. Article 136 Clause 2 is an exception to Clause 1. Reason is, if we say any court, any tribunal in Clause 1, does it include an order or a judgment passed by the tribunal or any court constituted under the Arms Act? The answer is no. That is the exception. So any order, any judgment, any sentence passed by any court or tribunal constituted under the Arms Act, SLP will not lie. That is Article 136 Clause 2 says. So having understood the widened power of the Honorable Supreme Court, now our focus will be on how to draft SLP in criminal matters. So first and foremost is Order 22 of Supreme Court rules deals with drafting of SLP in criminal matters. But which power, which article empowers the Honorable Supreme Court to frame rules? Article 145, Clause 1, which empowers the Honorable Supreme Court to frame rules. Let me read, dear friends, for you Article 145. Article 145 of the Constitution deals with rules of court. Clause 1 says, subject to the provisions of any law made by Parliament, the Supreme Court may, from time to time, with the approval of the President, make rules for regulating generally the practice and procedure of the court. So it empowers the Honorable Supreme Court to frame its own rules to regulate the practice and procedure of the court. A. Rules as to the persons practicing before the court. This is very important, dear friends. Why it is important? Advocate on record. It is introduced by virtue of Article 145, Clause 1A. Because rules as to the persons practicing before the court, advocate on record, practicing before the court, and they can qualify only after writing 4 subjects. How we are all regulated? By virtue of Article 145, Clause 1A. Now moving on to B. Rules as to the procedure for hearing appeals. Rules as to the procedure for hearing appeals and other matters pertaining to appeals, including the time within which appeals to the court are to be entered. So this is what concerning for today's topic, dear friends, because Order 22 deals with SLP in criminal matters, and this is the appellate jurisdiction. If you look at 145 1B, rules as to the procedure, that is Order 22 for hearing of appeals. SLP is also appeal and other matters pertaining to appeals, including the time. We say SLP has to be filed within 90 days. At times there are circumstances where it has to be filed within 60 days. When a matter where a sentence is death sentence imposed by the High Court, it is 60 days, not 90 days. So therefore, who has prescribed this limitation? Supreme Court rules prescribes the limitation by virtue of the power guaranteed under 145(1)(b). So this is how we have to study, dear friends. Now moving on to Order 22. Special leave petitions in criminal proceedings. So we have seen Article 145(1)(b). Now first, rule number 1, sub-rule 1. Let me ask the question first. See, our approach is towards the Supreme Court rules is, we try to find out questions. What is the need for this rule? What is the rationale behind bringing this rule? Only when we try to explore, when we ask ourselves this question, then we can identify what is the value behind it. First question is, I have put a question, when SLP can be filed? That is the first question. Order 22, Rule 1, Sub-Rule 1, we are asking a question, when can we file special leave petition in criminal matters? There are two ways, dear friends. Now, assuming that we are aggrieved by the High Court order, let me give an example. A person, an accused, is found guilty for the offence committed under Section 302 of IPC, and he was sentenced to, say, life imprisonment. Now he is aggrieved because he don't want to go behind the bars. He wants to prefer special leave petition. So he approaches us. This approach is directly when he comes directly to the Supreme Court, the limitation is 90 days. The exception is, here they have imposed only life sentence. In case if they impose death sentence, it is 60 days. This is one way of filing special leave petition. After the judgment is over, passed by the High Court, you come directly to the Supreme Court to file SLP under Article 136. 90 days is the time limit. Exception is 60 days only when it is a death sentence imposed by the High Court. This is one way. Yet another way to come to the Supreme Court is, once life imprisonment is awarded by the High Court, the aggrieved person, the convict, can make an application to the concerned High Court judge, seeking a certificate to be issued under Article 134 capital A, to certify that it is a fit case to go to the Supreme Court. So there are two possibilities. Once the application is moved, the Honorable High Court may allow the application. If they allow the application, it becomes a criminal appeal under Article 134. Therefore, there is no need for filing special leave petition. There is yet another possibility is, a certificate may be rejected. If that is rejected, then what is his remedy is, he can come to Supreme Court by filing special leave petition. The limitation is, now the limitation is only 60 days. When he approaches the High Court for certificate, when High Court rejects, refusing to grant certificate, thereafter he comes to the Supreme Court, the limitation is 60 days. So for better understanding, when he approaches the High Court after the refusal of the certificate, 60 days, when there is a sentence imposed to death, then 60 days, 90 days is when he comes directly to the Supreme Court and filing special leave petition other than the death sentence. Hope it's clear, dear friends. Now let me read. Order 22, Rule 1, Sub-Rule 1. where leave to appeal to the court was refused in a case by the High Court, a petition for special leave to appeal shall, subject to the provisions of sections 4, 5, 12 and 14 of the Limitation Act 1963, be lodged in the court within 60 days from the date of order of refusal. This is one way. And in any other case not involving sentence of death, that is within 90 days from the date of judgment or order sought to be appealed from, and in a case involving sentence of death within 60 days from the date of judgment or order sought to be appealed from. Dear friends, I am not reading everything. What I am focusing is on the important points. Now, what is the definition of order of refusal of a certificate? That is given in the explanation. So now they have given the explanation. When the convict was awarded life sentence, as I said earlier, a certificate is moved to the High Court to grant a certificate, therefore he can prefer an appeal. If that certificate is rejected on the ground of limitation, on the ground of maintainability, then that will not come within the purview of order of refusal. Then what will come within the scope of order of refusal? That means the Honorable High Court will see whether does it fulfill what are the conditions mentioned in Article 132 or Article 134. What is Article 132? That is a civil appeal concerning the substantial question of law as to the interpretation of the Constitution arising out of civil proceedings, arising out of criminal proceedings or any other proceedings. Then only the certificate will be issued under Article 134 capital A. That the Honorable High Court will look into it, whether does it fit within Article 132 or does it fit under Article 134 in criminal matters. If that is done, if that conditions are fulfilled, then certificate will be issued, otherwise certificate will not be issued. If certificate is rejected on the ground of limitation or on the maintainability, that will not come under the order of refusal, dear friends. That is what the explanation says. Explanation. What is, I am asking a question, what is order of refusal? For purposes of this rule, the expression order of refusal means an order refusing to grant the certificate under Article 134 capital A of the Constitution, being a certificate of the nature referred to in Article 132 or Article 134, as the case may be, of the Constitution on merits. So this is what they are saying, order of refusal, and shall not include an order rejecting the application on the ground of limitation or on the ground that such an application is not maintainable. So hope this is clear, dear friends. Now we are moving on to Rule 2. Now the question what I am posing to myself is, do we need to file an order refusing a certificate? Generally when we come to the Supreme Court, we file the order, impugned order, that is the order which is under challenge before the Supreme Court. Now after the order of refusal, do we need to file that order also before the Supreme Court? The answer is no. Why? This is the answer. Rule 2 says, Rule 2 of Order 22, where the period of limitation is claimed from the date of a refusal of a certificate, it shall not be necessary to file the order refusing a certificate. It shall not be necessary to file the order refusing a certificate, but the petition for special leave shall be accompanied by an affidavit stating that the date of the judgment sought to be appealed from, the date on which the application for a certificate was made to the High Court, the date of the order refusing the certificate, and the grounds or the grounds on which the certificate was refused, and in particular, whether the application for a certificate was dismissed as being out of time. So, we will be stating in the affidavit itself when an application was moved, when it was dismissed, on what ground. More particularly, whether it was dismissed for limitation or not, that is to be stated. Now, moving on to Rule 2, Sub-Rule 1, dear friends. The provisions contained in Rule 3, Clause 1 of Order 21. The provisions contained in Rule 3 within bracket 1 of Order 21 shall with necessary modifications and adaptations be applicable to these petitions seeking special leave. Therefore, what they are saying is, what is applicable under Order 21 Rule 3.1 applies with certain modifications to the SLP criminal also. So, what does it say? I want to draw your attention to now Order 21, dear friends. So, Order 21 Rule 3.1 containing nearly from A to G points are there. So, this also applies to SLP in criminal matters also with certain modifications and adaptations. What is that? The special leave petition under Article 136 has to be filed in the format as prescribed under form number 28. If you look at form number 28, it talks about civil appellate jurisdiction. But we are talking about criminal matters. Therefore, the rule says with certain modifications, we have to change it to criminal appellate jurisdiction. The same format with certain modifications. Thereafter, how the sequence has to be? It has to be stated with the list of dates and events, and it must be in chronological order. And what is to be stated in the events? List of dates and events we are preparing. Do we need to state all the facts? Not necessary. We need to state the list of dates and events. Those events must be material events, material facts. And no separate application for interim relief. This is very important. Generally in the High Court also, as well as in the trial court, we move a separate application for interim relief. Whereas in the Honorable Supreme Court, in the format of special leave petition, interim relief is sought in the SLP itself. There is no requirement of filing a separate application for interim relief. Thereafter, dear friends, 3.1d, which deals with the documents. So, whatever the documents, we file it along with the special leave petitions. Maybe the trial court judgment, maybe the depositions of the witnesses, the memorandum of appeal which we filed it before the High Court. So, those documents we annex it along with the special leave petition. What is the reason to annex all those documents? The reason is to support the question of law and the grounds that we asked in the special leave petition. So, whatever the documents that you are going to annex, you have to ask yourself this question, whether is it going to support your grounds asked in the special leave petition? If the answer is no, don't annex it. If answer is yes, annex it. Because ultimately, dear friends, our destination in the SLP is the prayer to set aside, grant leave against the impugned judgment passed by the High Court. So, when you are going to challenge that is the prayer, you have to create an atmosphere, you have to create with documents that order has to be set aside. Therefore, we are seeking the interference from the Honorable Supreme Court to set aside that. Therefore, we cannot orally mention it. It should be supported with the documents. That is most important. So, every documents must support our questions of law and grounds asked in the special leave petition. And how do you, when you make the annexures, It has to be in chronology, and every annexures cannot be annexed collectively. We cannot say that entire trial court record is annexed as annexure A1 or annexure P1. We cannot do that. It cannot be filed collectively, dear friends. It has to be annexed separately. Annexure P1 means plaint, P2 means written statement, like that. There is no collectively. And it has to be indexed separately. If we want to produce any documents, those documents has to be, whatever the documents which we annexed before the courts below, those documents has to be annexed. In case if you are unable to, if you are filing some additional documents, if you are introducing a new documents, how will you do that? Because ultimately the justice is to be done. These are all the procedures. When PIL was initiated by Honorable Justice V.R. Krishna Iyer and by Honorable Justice P.N. Bhagavati, my lords have held, we are not concerned with the form. We are concerned with the grievance. We are concerned with the justice. So therefore, writ petition, they have got the format. But even a letter is sufficient to warrant our interference. Form is not important. The justice is important. And all these procedures are handmaiden of justice. When justice has to be done by allowing the party to file or introduce a new document to the court, only thing is the party has to say what prevented him from filing those documents before the courts below, and what is the necessity to file it now. When he is able to establish these two grounds, then the Honorable Supreme Court may allow the application to file additional documents. And these documents has to be filed with the permission of the court, seeking leave of the court, to introduce any additional facts also, to introduce additional documents also. So you have to seek the permission of the court. And everything, dear friends, once SLP is prepared, it is accompanied by the documents. The most important aspect is, in my humble opinion, what gives life accountability to the special leave petition is affidavit. Reason is, we as an advocate practicing in the apex court or wherever, whatever the court, wherever the court we practice, how do we know what has happened in their life? Who attacked whom? What was the motive? And what was the dispute between those people? Nobody knows. Client approaches us and we seek, please give us the papers, give us the judgment. Then we read and we understand. Right? Only based on the black and white. So if he is going to state certain material facts to you, who is accountable? Whether advocate is accountable or the client is accountable. So therefore, affidavit is given, deposed by the client. So you will say, I have read the entire contents of the special leave petition. I have understood the same. The facts stated therein are true to my knowledge and belief, and annexures are all the true copies of the original. Therefore, it is presumed that he is giving all true facts. Otherwise, it amounts to fraud. It amounts to giving false evidence before the court, and he is accountable for giving false evidence, and it is punishable offense. So therefore, dear friends, and one more thing, I will tell you one aspect with respect to the affidavit is concerned. One of my friends, an advocate on record, this is a live example, dear friends, happened. One of my friends, he is an advocate on record. He has filed a special leave petition. It came up before the Honorable Judges, Honorable Justice presided by Honorable Justice Singhvi. And the facts of the case goes like this. An illiterate lady was cheated by the neighbor. Her property was taken away by forging her signature or something. So she has lost the property. Now, before the Supreme Court, she is challenging the High Court order. And what is her case? Her case is she is an illiterate and she has lost the property and she was cheated by the neighbor. When the matter came up before the Honorable Court, before my friend started arguing the case, the Honorable Judge asked the advocate to come to the page number 21 of the affidavit. Page 21, which deals with an affidavit. Then asked the advocate on record to read that affidavit. In the affidavit, an illiterate lady stating that I have read the entire contents of the special leave petition and all the material facts are true to the best of my knowledge and belief. Everything is stated. Then the Honorable Judge posed a question to an advocate on record. Your case is built up on that she is an illiterate lady, unable to read or write, therefore she has lost the property by the misbehavior or misappropriation by the neighbors. Now you have read the entire SLP. Then he said, my lords, this may be a wrong from my side. As an advocate on record, I should have been very careful. I must have written as if it was explained in the regional language and she understood the contents thereof. I have committed a mistake. If you have committed a mistake, suffer for the mistakes. Dismissed. So therefore, dear friends, by one mistake, the entire property goes. And though advocate on record has admitted his mistake, but who is the aggrieved party? Aggrieved party is the client. So therefore, we have to be more responsible, because if you are going to do our act and we are going to be held responsible, then fine. You did it, you suffer. But for our mistake, somebody is going to suffer. Therefore, we have to be extra cautious. Therefore, it is a noble profession and learned profession whereby we are fighting for others. So, thank you so much, dear friends. This is what about the SLP criminal matters, and we will be dealing it in detail in future sessions also.